we're looking
So
at 7349, right?
7349 has multiple ways we fine it. Right. So if you look on the first page, we have an employing an unlicensed.
That's 1,000, and we're leaving
Right.
that alone. This next one, it's 250 for the first offense. You're saying that existed, but what was it previously?
It existed as $1,000
As
before,
$1,000,
right,
because there is no strike-through.
right.
Original, okay.
I have a question.
Uh-huh.
Knowing that we were having discussion earlier about access, is it possible, knowing that we're distinguishing access to the actual establishment?
The interruption. Your conference contains less than 3 participants at this time. If you would like to continue, press star 1 now.
No problem. So since we're working on defining or distinguishing access to the actual establishment, which we do see that, where there are some licensees who won't allow inspectors to get in at all, that being an issue that we have at 7313, which the proposed violation amount is 1,000, but then distinguishing it from actual cabinets, things of that nature, is it possible to have that subsection under 7313 so there's not confusion? Because 904, from being on the board in DRC, I immediately identify with identification, or not having identification, which is listed here.
We can't because we're not changing the statute.
Okay, got you. So we still have to work on what that means,
Right.
the access.
Right.
So as we're working on the language and defining access, I would like to recommend that we also help establishment owners understand, if possible, access to the actual establishment, because I know that we get a lot of appeals from people who are just like, the cabinet was locked.
Mm-hmm.
We do see it with the actual establishment, but then I do feel that there might be some confusion.
We have put that information on the actual license. We've
Okay.
put it in the application package. We've posted about it.
Understood, okay.
Not clearly in the fact that if a drawer is locked, so that could be something we could look at. I think we have even in. Tammy just mentioned a great point that we could certainly add that to one of our tutorials that's coming up
Okay.
to help with that. But they don't understand it.
Okay,
That was one of our issues, is why we wanted to clarify what access meant.
okay. Are there any additional questions or comments?
Actually, I think we were talking about 7349, and I'm very supportive of this change. This is actually quasi what the RC does anyway. The problem is the people that don't appeal it, and there are many, would get the higher fine. So we need to codify it, not just give them a break in the RC.
Right.
So I'm really supportive of lowering this from 1,000 to 250, 300, and 500.
Okay, I see that we have some public comment.
Fred Jones again. And I am very supportive of the 7349 change. Just hearkening back to the conversation about access, I think frankly it'd be premature to raise the fines
Agreed.
for access until we get that clarified.
Agreed.
And then just a question, you don't have to answer it to me, but what would be the difference between access and 7313 and interference, 7404?
It's a big difference. One is you're blocking us from getting in. The other one is put your hands on our inspector. You have made, I could go on and on about things that have happened.
So interference is almost a personal
Absolutely.
blockage as opposed to access, which may be locked, inaccessible.
Absolutely.
Right.
One of our biggest things that we consider interfering with an inspection is when we walk into a salon and absolutely everyone runs.
Right.
And we are left with only the inspector in a salon, sometimes with a client with hair on the product on their head.
Right, right. I said skateboard, not
Right?
skateboard. Yeah, well, that kind of interference, throw the flipping book at them. But until the access comes along, let's.
Right. So we have more fines that I'll just go over that we're recommending. The next one is the labor rights notice. This is to implement AB 2437, that establishments now have to have a poster, will go into effect July 1 of this year. The Labor Commissioner is tasked with creating that sign, but we will inspect for it and issue a fine per the new statute. So this sets the new fine amount at the same as what we have our health and safety poster right now. It should be back in the front.
So we have some public comment, yes.
Jamie Schrabeck, Precision Nails, just two things. Christy, as you were describing that earlier, I want to clarify that the unlicensed activity would apply to anyone in that salon, not just someone employed, because as Mr. Tyler pointed out, most people working in salons are booth renters.
And we don't ask, so it's anybody.
Right, okay. And then going on to the point you just made about the upcoming poster that we're expecting from the Labor Commissioner, if we could please, there's enough ugly signage that we have to post. If we could make that something that we could post in our back room along with all of our other labor posters that we already are required by state law to post, I would appreciate that. And just keep that consumer notice be the only thing that's visible to consumers.
So the bill, I believe, says it needs to be posted where employees are.
Good.
I don't know what the sign's going to look like. It's totally the Labor Commissioner's job to prepare that sign. We will only inspect that but it does say that it has to be where the other employee information is.
And I'm fine with that. I think in New York, it has to be posted where everyone can
Yeah.
see it. Okay, thank you.
Thank you. Are there any additional questions or comments?
I have a comment more. Going back to 7313, access to establishment for inspection, there are fines currently of $250, $500, $750, correct?
Correct.
So if I'm an owner, I can take the gamble right now. I can bar them twice and only cost me $750.
Correct.
And we're thinking it should be $1,000. Why can't, I know we're debating about what access is, but this is actually getting into the building.
Correct.
Is there any reason right now not to raise the second and third violation to 1,000? First time, 250 slap on the wrist, basically, you better let us in. Second time, now it's a little bit more painful for them. Is there any reason not to do 2 and 3, to raise them up?
Not in my opinion.
Madam President?
Yes.
Clarify that?
Yes.
Or try to at least. So it referenced in 7313.
Yep.
And if you go back to your proposed clarification definition
Yeah.
regulation, it references that same code section. So don't take the title on the spreadsheet to mean that it's only access to the salon. Because according to your own proposed language, which you've now put back down to committee, it also includes all rooms,
Right.
drawers, cabinets, rollabouts, and closets.
Right.
So 7313 isn't just about the front door, it's about everything.
Correct.
All
I
right.
see.
How about let's raise at least the third violation, because hopefully by some time somebody gets the free will to clarify this access stuff.
Dr. Weiss, I just need to get some clarification about the labor poster. Are they available now?
No, not even, the new labor poster, there's a new law for a new posting, and the posting is, the Labor Commissioner has a due date of July 1 of 2017 to have that poster ready.
Okay. When that poster become available, can you put something on the way up to make sure
Absolutely.
that, because I'll be giving an orientation to about 60 shop owners here in a month or so, and I want to make sure they're aware of that.
Definitely.
Thank you.
Thank you. So any additional, yes?
Seven 7313, are the new changes going to affect or be the same as the 904
E.
E?
I think that we tabled that.
Right. So there's not going to be a change to access at this point.
Okay. And one more. On page 1 of the fines, it's 7348, no licensee in charge of establishment.
There's no change to that.
But if the owner isn't a licensee, how does that work?
If the owner is not a licensee, they are still the licensee in charge because they are the holder of the establishment license.
The owner is the holder of the establishment license.
Correct.
But they still need a person with cosmetology esthetician, one of those licenses?
They do not. They are considered a licensee.
Oh, okay. Thank you.
So I have a question based on what Andrew brought up regarding the increase in fines for at least maybe one of, like, the second and or third violation. If we were to increase the fine for 7313, while we work on the language to help prevent some of the issues that we do see of establishment owners avoiding inspections sometimes 2 times in a row, would that impact the work we're trying to do with at least the language part of it, this fine schedule?
Well, the only thing I would caution is that we could potentially end up changing that fine now and changing the fine once we define the language.
Okay, understood.
So it's whatever the board wants to do, we can pursue, but
Clarification, Christy, does 904E exist at this
No.
time? Right, so that doesn't even exist.
So
So,
if we change it, then it's going to impact how we currently deal with access. Like if we were to adopt today this new fine schedule for 7313, knowing that 904E does not currently exist because we need to define access, then it would impact how people are cited as of now.
because we have asked us to go back and talk more about access, I do not think we would, 904E is off the table
Okay.
because it hasn't been defined.
But in theory then, if we do raise the first one to 1,000, whatever,
Right.
an inspector can go in and, if I can't get into a drawer, they might cite them for that.
Yes,
And get that
7313.
$1,000 fine.
Exactly.
Right off the bat.
Exactly.
Okay. Understood.
7313 exists today. For the first offense, 250, then 500, then 750. The board could decide today to pursue a change in that. But keep in mind that our intention was to increase it because we want to define access, being they've blocked us from entering. I don't know that we should cite somebody $1,000 because we walked in and they had a locked
Right.
drawer.
Agreed.
So I have a question.
Yes.
So Christie, if we're going to change any of this, there's no reason to go through regulations until we get it all down the way we want it. Am I right about that?
You mean any of the fine at all?
Well, that's what I'm asking you. Do you want to table or go back to the drawing board on one of them? Should we hold all of them until that's finished? I'm asking what's easier for you, so I'm doing.
So the reason why I would recommend that we make changes to the administrative fine schedule today is because we all know how long regulations take.
Okay.
And we have the implementation of the new labor law posting. So if we should at least get started on that.
So basically at
Can I
first,
say, I'm not quite sure yet, just give me a second. So if we're not going to do anything on 904E, can I make a recommendation, depending on how the other board members feel, since the first offense on this one is often the owner's not understanding they have to have keys for other things, is that we lower that first offense to 100, but keep the other two the way they are?
On what? On which section?
Which one?
904E, access to establish for inspection. Since we're not going to do anything on that one today, or that's what I've heard, then we're going to wait. I would like to consider lowering the first offense to 100.
So
but it doesn't even
It's
exist.
just a lack of knowledge.
if I could just clarify what I'd like to see on the administrative fine schedule today. I think if you look at the memo, the explanation memo that came along with these regs, and you look under page 2, under schedule of administrative fines, we have 5 recommendations on fines. we now say 7313 and 904E should be off the table until our next meeting, at a minimum, okay? So what we would like the board to approve today is to update the fine schedule for 7349 on employing an unlicensed person with an expired license, 7353.4 for the labor rights notice, and 7404L interference with inspection, which we haven't really discussed yet. But those are the only three that we believe should go forward today.
Okay.
Okay, so, Christie, the only comment I was making on 904E was a little more forgiveness on the first offense, since we're not gonna act on it today, to have people consider it that's possible.
Right, got it. And I would actually agree with that. So I think when we further go down and clarify our access, I think I would agree with that, that should be a lower.
Yeah, there's a lot of well-meaning people come saying, gee, I didn't know about this.
Right.
I'm gonna do it from now on, so please help me out. We usually lower the fine anyway, but that doesn't help the people that say, well, $250, I'm running a big establishment, I just really don't have time to go and appeal it. So I think we should recognize that the DRC often lowers the fine and, on the first offense, and so maybe do that, grant that to everybody else as well.
Okay. So if, should I go on to interference? So I just want to make a note that we are recommending on interference of inspection that fine increases to $1,000 for each offense. Right now, first offense, $200, second offense is $300, third offense is $500. It is absolutely not a deterrent for people to interfere with the inspection. These are egregious violations. They are, like I mentioned, people running away, people physically getting in we recently had an inspector that was locked in the salon. We had to call the police. So paying $200 to do that is just not a deterrent for individuals.
I agree.
I'd like to make a motion
Yes.
that we accept the increased fine schedule for 7349, 7353.4, and 7404, and revisit the fines of 7313 and 904E once we bring back the definition of access to the board.
Perfect.
I second.
I second that.
And
Too late.
again, perfect, with the addition maybe of, so you've approved what you laid out, and you are delegating to your EO to make any non-substantive changes as needed and to go forward with the rulemaking package.
Yes.
So,
I accept that as well, on the second.
and just a reminder that it's to start the rulemaking process. So what we see and what we talk about today and what we talk about in 2 years might be different.
Okay, so there is a motion on the floor. Are there any additional comments or public comment? Seeing none, then I will start to my left with a vote.
Lisa Tong, yes.
Kokolishin, yes.
Dr. Carey Williams, yes?
Andy Drafton, yes.
Bobby Anderson, yes. Sergio Amaro, yes.
And on the phone?
Rich Judge is yes.
Okay, so the motion passes. We'll move on to the next item.
So our next regulation package is, and again, I know I keep repeating myself, but this is the first time the board's seeing this, so it's, we welcome any input that we have to start the regulatory process. So this is for our disciplinary review committee. We've been recently enlightened that the disciplinary review committee members cannot vote on an appeal to the ALJ. So when you have a disciplinary review committee, someone comes in and appeals their citation, if they then have the right to appeal to an administrative law judge. If there's an appeal to an administrative law judge, the process happens and then it goes out for mail vote. So the board members should not vote on something that they've already voted on. So this is a proposal to set the disciplinary review committee as non-board members. Right now, you have to be a board member. And so this is to allow to allow the board to appoint members to the disciplinary review committee. So that is the very rough draft proposal that's being presented today, and we would welcome any comments for suggestions to that process.
I have a quick question.
Yes.
In theory then, we could have multiple DRC committees, like a DRC committee based out of Sacramento, one
Yes.
based in LA, one based in San Jose, one based in San Diego, and actually serve those committee hearings there.
Correct.
Those might be shorter because it's more regional.
Right.
And less time because it's all
Less
that,
money.
less money, et cetera, et cetera. One other quick question and then I'll, since one is not associated professionally or financially with that industry, does that mean they're gonna have to fill out a Form 700 disclaimer kind of a thing? All the kind of stuff like I have to do, or are they, we take their word for it? Is there any worry about stuff like that?
I don't think we're there yet.
No, I don't, I would have to clarify that with our conflict of interest people in the department. Rebecca, I don't know if you would know that answer.
No, I don't know.
Normal committees don't, like our health and safety committee.
Yeah, but this particular language, as he's mentioning, sort of serves it up to make it clear that you're creating this standard. So that could create that kind of an
Okay.
issue. It kind of brings up these other issues about who might be on the committee. This particularly seems to state that a board member could be on the DRC, but it sounds like from what you're saying, you're not intending for a board member to be on it.
I think it's really rough draft, open for discussion, so.
Okay. So just to back up a little bit, if, as it's written, if a board member could be one of the people appointed, I guess, just to clarify on the recusal issue, if a board member were to be on DRC, then if the case were appealed, then they would recuse themselves if they'd already acted kind of like at a prosecutorial informal conference level, like the DRC does. So a good question might be how much this is really an issue, how much this happens, how much it's affected, so.
Often.
Okay, so it's pretty frequent that
Very.
a case is then appealed and the board would see it again. Okay, so for example, regardless of whether, so for example, right now you've got, let's say 3 members, just to keep it simple, let's say you have 3 board members on the DRC. Each of those 3 members would have to recuse themselves if they saw a case again.
Right.
Under this new proposal, if, let's say, 1 out of 3 was a board member, you would still need that one board member to recuse themselves if
Correct.
they ever saw that. So it would still be an element of tracking if you had
Right.
a board member on
Right.
on the DRC.
Okay. And actually, that was going to be one of my questions, knowing that we could set up these individual DRC committees, that I would like to see at least one board member serving on the DRC, because I know, being an active member of the DRC for my 4 years on the board, I know that a lot of regulatory changes have come from observations that we see in these very frequent hearings that we hold at least once a month, which allows us as members to be very active in communicating with you and other board members what we see our concerns are. And I feel that if we're able to do that, it creates some sense of balance where, for example, if I were to continue to participate on DRC, then I could easily just recuse myself, because I do oftentimes see cases that I remember, like, oh, I remember when this person, came before, the DRC. And then I reread the case, see what the ALJ says. Sometimes I agree, because maybe it's something I, didn't understand. Sometimes I still have an opinion. But all of that to say, I would like to see at least one member of the board still active with the DRC. If that's something that's possible, I think with a 9-member board that at least one person can go.
We had to scrape.
I have some comments too.
Yes.
So, I don't think it's that difficult to track the cases that the board members rule upon. I definitely don't want to see board members excluded from this. I know it's often difficult to have a full complement of the DRC of 3 people, sometimes even a hard time to find 2 recently, but we should not exclude board members from it. We can easily track these and pull them. We're doing it now. And so I would not be in favor of anything that would exclude board members, number 1. Number 2, any people that are appointed should be appointed from past board members. And my daughter's calling me, I'm sorry. also past board members, but what I'm most concerned of is conflict of interest. We've had an issue in the past with a board member of perceived conflict of interest on the DRC. So and this was some time ago. So unless people go through the training on conflict of interest, even on sexual harassment and other issues, because you have people appealing in front of you, I want to make sure that they're schooled and educated so that we don't get in trouble. So I think there's a lot of issues with this. So thank you.
Thank you.
Mr. Hedges, actually, you bring up a lot of great points. You talked about consistency for one, and I think that you were couching that in terms of having board members on, but there are other ways to get consistency. So for example, if your draft language were to lay out some kind of standards, or whether it has to do with experience or licensure or something of that effect, because the sort of standard is going to be different than what a board member is held to. So something like that could create some consistency with a different standard. So for example, there are other boards that have diversion committees. And so dental board's an example. They've got section 1020.4. It's a different topic because yours is disciplinary, theirs is diversion, so it's much more specialized. But the idea is there's some sample there as to how to create a standard of who would be eligible and who should be on that kind of a committee. Let's see, another thing you brought up was conflict of interest and tracking, and I think from what I gather, you have different members being pulled onto DRCs in different parts of the state, mostly Northern California and Southern California at different times to handle different cases. And from what I'm hearing today, it's relatively common, if not frequent, that the cases at DRC are appealed to OAH and then come back to the board in mail ballot form. So I don't know if it is very easy to track, because again, the recusal is not going to be based on whether or not a board member happens to remember, oh, I remember this case. It's going to be more of a staff level of, we've got to sit and weed out anytime these three would have seen this case, those three are now recusing themselves, now do we still have a quorum on this mail ballot? And you're going to be sorting out from Northern California to Southern California, each DRC set of three that saw, or even if it's one board member, let's say, you're going to be sorting out each time that board member was exposed at DRC to one particular case that may have been appealed. So I can't speak to that, it's a factual issue, but it might be overstating it to say that that's an easy feat. Let's see, and you brought up, like I said, consistency and the final thing is you mentioned about availability and trying to have the kind of access to members to serve. And I think that's part of the reason that your staff is proposing to look outward and to look at other people who could, rather than sharing their time with board responsibilities and DRC, you're looking out to people who can devote a chunk of their time that they've committed just to DRC. So just some thoughts to consider after that.
I'm actually in favor of bringing non-board members on. I just don't want to take it out of the board's purview. And the reason that I don't want to is that many of the regulations that have changed, we brought forward from the DRC because of complaints about the way they are implemented. And so I think it's good to have board members involved with this, with this process, because that's how we learn, especially since we're televising our board members' meetings. We don't have nearly the amount of people. We used to have 100 people at our meetings talking about various issues. We don't have that anymore. So this is actually a more connected way for the board members to hear from the public.
I'm sorry, could you clarify, do you mean at the DRC meetings that you have members of the public coming? Or?
Yeah, I'll give you an example. We had just one example of many. We had a salon owner come and point out that some of the things they had gotten violations for were outdated equipment that's not used in the industry anymore. And so we brought this forward to Christie, and Christie worked on it immediately, and we got the regulations changed on what salon owners' equipment has to be.
Okay, so Mr. Hedges, if I may stop you there, you bring up a really good point. You said yourself that Christie was able to take the issue up and move it along. So my impression is that you do have staff at these DRC meetings who can pick up on any issues that would come up. And I think it is a little jarring to think of such a long-standing thing being changed or shifted so dramatically. And I can see that from both your comments and Dr. Williams. You're both referring to the kind of board-level involvement that is sort of seeing things through. But that's precisely the kind of conflict and need for recusal that I think the attempt is to prevent. And much like other board members on other agencies, you're still involved with the process. You're still seeing cases come back to you after an ALJ has addressed them, or if they go to stipulated settlement, you're still seeing the way that your laws and regs are playing out. And again, your staff would be at the DRC level able to, you're also preventing, by the way, some Bagley-Keene pitfalls, if you will, to having 3 board members hearing issues that aren't pertinent or germane to the DRC matters that are in front of you. So I think there's a lot of, and again, you're suggesting not just having the 3, but even if it's just 1. So anyway, I just wanted to chime in on each of those points.
Thank you. We have,
Let me just parry a little bit with you on the issue of the DRC staff. The DRC staff's job isn't to bring back these issues. I would be comfortable with an executive staff person being at the DRC to listen to that. But quite frankly, I don't think that the DRC staff, with all they have to do, will be communicating issues that are brought up that need to have changes made with the board, nor would they be comfortable with that.
okay, thank you, Mr. Hedges. We have some public comment.
Fred Jones. So the tension we see is industry wants more timely, closely located DRC hearings, right? And that's the intent behind this, is it's difficult to get board members, 3 board members to these hearings. So that's the intent. We support that. But there's the other side of this, which creates tension for us, is, and Mr. Hedges alluded to it, kind of described it, is the reason why we supported a board structure to begin with back in 2003 was because it provides a little bit more public accountability, a little bit more opportunities for industry to connect to you all, which are kind of setting the policy framework for the regulations, as opposed to just staff. Because prior to this board structure, it was a bureau. And there weren't as many opportunities to interact with staff. So I would suggest, and I think Dr. Carey was heading in that direction, is that you include at least 1 board member in each of these committees. That's better than status quo, which requires just board members, and 3 of them. And so that will keep a board member involved. And that gives somebody a conduit, both to the industry, but also to the rest of your board members. As far as recusal, that's an existing problem right now, with or without this proposal. The recusal issue is an existing issue. So, with all due respect, it's a red herring for this proposal, because you're going to have recusal issues one way or the other unless you totally remove board members from DRC. We would oppose removing all board members from DRC. And then I'll finally make one other statement, and Mr. Hedges already made this. DRC is an excellent opportunity for new members to see the good, bad, and the ugly of our industry. And so I think removing members from the opportunity to serve is wrong-headed. In fact, I would require each of these committees to have at least 1 board member to be part of it. Thank you.
Thank you. We have some more.
Yeah, I just want to make a comment that I agree with Dr. Carey on this also, and I think Richard mentioned the same thing, that it should be a combination. And Richard used the word consistency, which I feel very strongly about, because if we're heading in the direction of multiple DRC committees in different geographic areas, we want to have consistency that what DRC is doing in Sacramento is the same sort of standard and consistency of how they deal with cases in Southern California. So a common thread might be a board member who sort of, we all sit here together and talk about issues, and also who have served on previous DRC to know that, this is sort of how we deal with cases like this. And of course, this is too premature, is that, does it mean that a petitioner from Northern California can only be seen by the Northern California DRC group? Or can they choose? I mean, if they hear that, okay, hey, they're more lenient in Southern California, can we, of course, those are all issues that will be tressed out much later. But that's what I am concerned about, is the consistency.
And yes, I would like to add, I agree. I think that the public, as well as industry members who come to the DRC and are able to interact with us as board members, especially new licensees, or even licensees who've been in the industry for years and they, never gotten a citation, it really allows for the communication, especially as an industry member. I know that I've found it very valuable being able to communicate to other industry members, but also as a board member to know that we're taking their concerns into consideration and being able to talk to our executive officer, our other board members as well about those issues. I think that when I imagine that we create DRC committees where there aren't any board member involvement, then my question would then be, will they then create or generate reports so that as board members we know what's going on? Will we have a separate committee? Because then, as Richard said, right now, because at least 2 of us are present, we kind of automatically do reports in the sense of verbally or emailing, Mrs. Underwood, or, discussing them at board meetings. But if we're not present, will there be another way that these members are communicating to us what they're observing or experiencing at DRC committee hearings so that we know? I feel like it would create more paperwork or process, not that it's impossible, but I know I would want to know what these committee members now are experiencing when they're, holding the hearings.
I have a comment as well. I agree. I do think that at least one board member should be involved in the process, and that also is because looking at it from the other side of this, in that whoever we appoint may or may not be a prior board member or not. We haven't discussed parameters for who the candidates would be, but these are people who may not necessarily be attending our meetings or even knowledgeable about what the current board is discussing. And so I would have concerns about whoever we appoint may or may not be in sync with what the board is currently talking about or deciding. And so I do think that, like Coco has mentioned, consistency in terms of what the board would like to move forward with and how DRC moves forward with some of the things that we discuss. I think having a board member present would help make that connection.
Are there any additional comments or questions?
So keep in mind that this is just a, beginning discussion. And it can stay the way it is. And we are removing DRC members now from mail votes that they should not be voting on. So if you voted on something in DRC, you're not getting a mail vote for it.
Just a comment, if I may.
Yes.
I spoke very passionately about having board members involved, but I'm not against this regulation change. I just want to keep board members ensconced in the system. Keep in mind that the Senate Business and Professions Committee holds us responsible for the good acts and the bad acts, and one of the ways we know the bad acts is DRC.
Thank you. We do have some public comment.
Yes, Dr. Washington, I just have one comment I wanted to ask. Do the manicurists and estheticians go to the same DRC as the barber and cosmetologist? Well, I see on here that, will there be someone on the DRC that have knowledge of those 2 areas too? Because right here, I just see barber and cosmetology.
Well, right now it's our board members. So we have public members and industry members. We currently don't have a manicurist at all, so.
I just wanted to throw that out. I was just reading. Thank you very much.
Thank you.
Should I make a motion that we move this to, I guess it would go to the legislation committee to look at it more, and also in that, to also look at other DCA boards and see how they handle things like that, because not the conflict of interest kind of a thing, but I am concerned that we are appointed by elected officials to represent the public, and so that's the standard we're held to. I'm assuming I was vetted beforehand, et cetera, et cetera. I'm wondering whether it's not that I don't trust Christie, it's just that the government holds us responsible, and this is kind of taking it out of that public oversight to a certain extent. And so, that's why, how do other boards handle it? If they have, you know, separate organization that does it, then, you know, I'm not as, you know, curious about it, but I'm not as concerned about it. But if they're all handled by their board members, then I don't know whether I want to be creeping out there.
So I do know that there's oddly only one other program under Consumer Affairs that has a disciplinary review committee, and it's the Bureau of Security and Investigative Services. So it's a bureau. So their DRC members are appointed by the governor, I believe. Maybe a mixture, I'm not positive, but they are appointed. Most other boards handle citation reviews with their executive officer. Obviously, they don't have 6,000 a month. But informal, like for a person who is appealing only the amount of the fine and wanting help, those go to the executive officers in most other boards. What we could look at is what Rebecca had mentioned is like the type of different types of committees other boards have. It's going to be different. It's not a disciplinary review committee, and look at how they're structured and set up.
I just want to comment.
I could comment to the president.
1 second, Richard. Miss Bobby Anderson had a question.
Not a question, a comment.
Okay.
I just wanted to say, having had an opportunity to sit in the audience and observe the DRC meetings and also sitting on the committee at one point, I do see the need that there should be a board member. I don't see it having none board members, at least one board member I would agree with.
Thank you. Okay, Mr. Hedges?
Yeah, I just wanted to, I think it should go to a committee for some discussion, but and some reworking, but it should be the enforcement committee who deals with these kind of things.
I will amend my motion to the enforcement committee, if I can get a second.
I'll second.
Second.
Okay, so we have a motion on the floor to defer this conversation to our enforcement committee. Is there any public comment at this time? Seeing no public comment, we'll call for a vote, starting to my left.
Lisa Tong, yes.
Kirkalishin, yes.
Dr. Carrie Williams, yes?
Andrew Drafton, yes.
Holly Cortez, yes.
Bobby Anderson, yes.
Mary Lou Amaro, yes.
And on the phone?
And Rich Hedges, yes.
Okay, so the motion passes, and we'll move on to the next item.
We all right to keep going?
Yes.
Okay. The next item is the review and approval of proposed language to establish when a fine is issued to an owner and an individual licensee. So this is for implementation of SB 1044 that went into effect January 1 of this year. So we have just proposed some language that's in your packet here. So again, we open it for discussion or any input, and hopefully we can come up with something that we can actually move forward to start the regulation process on this today.
So are there any questions or comments about the proposed language?
If I may then, I think,
I could actually say one thing.
please go right ahead.
Okay, go ahead, Mr. Hedges.
I'm in no way against this. I just want to make it clear that this gives a lot of discretion to the inspector. So we'll have to do some training on it.
Actually, the discretion would end up with our cite and fine program.
Okay.
Yeah, I agree with that, because I understand how it works, but I think that at the first level, so you guys don't get overwhelmed, we ought to do some training and get some consistency out of the inspectors.
It does appear from this language, it's hard to tell which level the determination might be made as to who knew or maybe could have known or that kind of thing. I think this, in other words, this, to make it more concrete, it says in the second line, unless the board's duly authorized representatives determine, and it's unclear if that would mean the inspector who's first making an assessment, possibly.
Would we say who duly authorized I
Not
mean,
typically. Typically, the board just is
Right.
carrying it out. And I think the statute seems to, so, excuse me, so it's now section 7407.1. That seems to lay out the idea that the board is going to determine when both should be cited, when one should be cited, or when the other one should be cited. And then it talks about, in the last sentence says, in making these determinations, the board shall consider the egregiousness of the violation, et cetera, and whether the violation is a repeated violation. So I think the statute seems to suggest a kind of standard as to whether it should be both. So in other words, if you could argue it's a very egregious violation, then the presumption would become, oh, the owner should have known, or knew or should have known, because it's such an egregious one. Or if it's repeated, if it's the second, third, fourth time, the idea is they knew or should have known, so therefore they could be cited. So I think maybe if that were laid out in here as the standard, it might make it more clear when the presumption would sort of kick in. It would sort of clarify why it is that they would determine whether or not they knew or should have known. I'm obviously speaking in a pretty broad and hopefully not too vague way, because it's not really tied to this language yet. But I'm basically trying to say that I think the statute maybe dictates, basically saying they either knew or should have known, and here's why: the egregiousness or the repeated quality of the violation.
So you think we should, what would we say?
So it could be something to the effect of the board may cite and fine both for the same violation if the owner knew or should have known, and there's a presumption that they knew or should have known if it's either egregious or repeated. That's just very roughly laid out.
Could I make a comment?
Yes.
So, I support what our attorney said, and I think we need some more specificity. Again, I'm not against this, and I might suggest, I'm sorry, Christie, to be doing this, but it's our first crack at it, that we might want to also take this to the enforcement committee. I think that there's some people in our audience that will want to weigh in on this, because they've weighed in on this issue in the past, and it might be a way to vet this out of committee before it comes back to the board.
We're then, just so the board knows, we're looking at several months before we can have a committee meeting. Unfortunately, we have some staffing issues in our board right now, and myself and our assistant executive officer are spending most of our time in Glendale. And so I don't know when we can have a staffing committee, a committee. And I also am concerned that this law passed January 1, 2017. So if there's any input we can, I agree as well. Perhaps maybe we can discuss it further and try to come up with something that we can at least start the regulatory process.
So it would be your recommendation, Christy, that we try to at least adopt this with like changes? So we can get
No, I think we should discuss it and how we want it to look
Okay,
today.
and finalize it today.
And by finalizing, meaning that we're starting the regulatory
That's what
process.
I mean, you don't want
Right,
to
right,
defer it to a committee.
right,
Okay.
right.
Thank you, Christie. I didn't realize the urgency.
But I still am unclear on how we could be that, on what we need to say in regs.
Yeah, and maybe rather than wordsmithing and sort of tinkering and picking at the language, we can look at what the intention is, and the board can approve what it's trying to achieve. And I guess what I was speaking to was, it seems that the statute lays out a bit more about what the standard might be. In other words, the statute
Okay.
is saying, you shall regulate when both should be cited, when just one should be cited, or this other one should be cited, and here's a consideration to use. So I think that sort
Right.
of lays out a bit more, and so that consideration that to use refers to the egregiousness or the repeated quality of a violation. And so, presumably the idea is, if those things apply, that's more reason to cite both. I think your second subsection might be dealing more with how to set the amount, but I think you have your schedule of fines for that. But please correct me if I'm reading that wrong.
Yeah, I was questioning why we needed Part B.
Would it,
I believe that's just a repeated language from what exists. So we don't. It,
can I, would it make any,
Further suggestion that we approve the concept in general and give the authority to Christie, working with legal, to work out the proper language.
Well, I think that's the intention at this moment, but I think the board would need to be at least clear on what it intends to achieve.
or ask the staff to achieve?
Right,
Would it
right.
make a difference if under A, we just end the sentence after sole responsibility for the violation, period, and take that established owner could not have been expected to know language part?
Yeah, I mean, I think what I'm basically suggesting is that in reverse. So rather than saying what they could not have been expected to know, the statute seems to talk about what we could assume they did know or would know.
Right.
If
Which
that
is
makes-
in number 2, because consider the seriousness, the egregiousness that you talk about, and
Right.
the first offense, it's already in number 2.
Right, but B doesn't talk about when to, or how to apply the citation, it talks about how much.
How to fine.
So B seems to say that whether it's serious or repeated should affect how much, as opposed to when to
when.
apply it, if that makes sense.
so, do you feel the statute's sufficient? Other than the fact that it starts off with that it
You
says.
shall regulate.
Right, it starts off, just so we're all on the same page, that the board shall determine by regulation when a fine shall be assessed. And then it goes on.
Yeah, no, it's still asking you as a board to determine when and how either both or one or the other should be cited. It's just explaining one of the considerations that would likely be used. So for example, I think it gives you the room as well to be to have more specificity. Let's say the board's, again, in your experience with your disciplinary cases, if your experience is, I'm trying to think of an example. I think it's a factual
it's
thing where I can't think of an
multiple offense.
example, but the idea being if there's some other factor that would say to you, no, they should definitely both be cited for the same violation because they own the salon and they are there practicing, and so each carries its own obligation, therefore, in this scenario, they should both be cited. As opposed to some other circumstance where you might, as a board, say, no, this is pretty much only falls on the licensee and not the person holding that establishment license. So
Right.
those are the determinations that the statute is allowing you to flesh out more.
So I don't know how we could lay out in regulation the specifics for every single violation.
Agreed. I don't think that's necessary.
Okay.
But I think, for example, if you said, the board may cite and fine both the establishment owner and an individual working in that establishment for the same violation, if the establishment owner knew or should have known of the violation, in other words, that's a violation that, yes, and assuming they knew or should have known, and then you would say the board could presume they knew or should have known if it's egregious or repeated.
Yes.
And you could even further
So then,
explain.
the problem, or the question I would have is how do we determine what an
What's
establishment owner should know? There's no education. There's no, I mean, how would we?
Well, because in other words, first of all, if it's repeated, I think the idea is.
Sure.
Right, okay. So then you're looking at the egregious qualifier in the statute, right? And I think then the idea is, and again, this is going to be more of a factual thing that I'm not as exposed to, but, you know, if it's something where a comb is left in the wrong disinfectant, and maybe the establishment owner wouldn't realize that this individual licensee had been doing it that way, maybe that's one thing. That's for a policy call for you guys to make. But if, for example, no one in their shop is sweeping up hair or bothers to clean anything, then I think the idea is it's so egregious that the owner of the establishment knew or should have known. Do you see the distinction there? And again, where that distinction falls is a policy call for you to work through, but those are, I think, the two considerations directing you in the statute, if that makes sense. As opposed to, I think, the concern maybe being that it is somehow about breaking down each and every violation and
Right.
saying, when would this know and when would that know?
Right.
But if you keep it, generally speaking, egregious and repeated and kind of go from there, I think you can have a layout that would explain why both should be cited in this situation, but, hey, we're only going to hold the licensee to account in these situations.
Okay.
Okay, so we do have some public comment.
Thank you. Fred Jones, PBFC. So as a co-sponsor to the bill that was with the senator at every meeting she discussed this legislation with from the outset, having been the one, along with your executive officer, to pitch this idea, let me give some clarity and background. So because your board doesn't recognize booth rental, that's kind of the problem here. But this started off with the egregious situation in which you have an independent contractor who's not under the control of the establishment owner, in which the independent contractor has a contract with the establishment owner. And if a violation, right now, the way the law is written, absent this implementation of the new law, which was intended to address this issue, right now, both get fined for the same violation, okay? The establishment owner gets fined for any violation that happens in a salon, even if it happens by an independent contractor with whom the establishment owner does not have the legal right to control, if they're truly independent. What's more, most booth rental contracts say, if I'm the establishment owner and I get fined because of a mistake you made, you have to indemnify me for my loss. In other words, you're going to pay, booth renter, you're going to pay me for any fine I have to pay for your screw up. So right now, we're in a situation where booth renters are actually paying double for the same fine. They're paying for their violation as a licensee, and then they're recompensing the establishment owner for the fine that she got because she's the establishment owner. So that was the background for us pitching this idea to Senator Wynn. She said, that's stupid. So let's figure out something to do. Well, she couldn't recognize booth renter because it's not in your Barber and Cosmetology Act. So that's the background and purpose to this, with one other addition. We as an association, therefore as co-sponsor of the bill, recognize that there is shortcomings to booth rental operations in our industry. A lot of them, and I would go so far as to say a majority of them, are truly not independent. They look at the establishment owner as their employer, the employer does the advertisement, the employer maintains the books, the employer does the credit cards and the charges and the receptionist. Oftentimes, I said the employer, the establishment owner provides the materials and the equipment. It's tantamount to being an employer. And I would say a majority of them fall into that category. So we don't want to create a situation, we as an association, and I don't think your board wants to create a situation where you're rewarding them for simply calling themselves independent and then removing the liability of the establishment owner. So I think, and I'm definitely off of Miss Underwood's gift list after this comment, if I'm not already, this is one that I would recommend a little bit slower walking. And as a co-sponsor of the bill, I'll get in between you and Senator Wynn if she has problems with this, because I think what the intent was to address the injustice of a booth renter, if he or she's truly a legitimate independent contractor, having to pay twice for the same fine. But it was also to send a message to those booth renters, you need to be truly independent. And so I would like to see a regulation that says, we will separate, and by the way, Coco, I really liked, at least for today, your suggestion of getting rid of that line, okay? If it's your sole responsibility, then you're solely held responsible. Nobody else is going to pay for your fine in addition to that. So I like that as a starting point. It's just striking, and that the establishment owner could not have expected to know, blah, blah, blah. And then leaving B because it kind of reiterates that. However, I would like to see a committee with some time to look this through, talk about what is the right to control. What are some of the indices that the site and fine staff could look at to say, this is truly an independent contractor, right? Do they carry liability insurance? Do they have their own independent business license from their local municipality, either city or county if they're unincorporated? If they don't have things, do they have a contract, a written contract, spelling out the lines of authority and responsibility? If they don't have all three of the things I just listed, why would you let them off the hook? Why would you let the establishment owner off the hook? They are an employer. And therefore, their quote-unquote booth renters are agents of the salon. So you have a justification for finding both. Because one's an individual licensee, they're going to be held responsible for their mistakes, and the other is the person in control of their actions. It's called agency law. So I do think this is one that deserves some slow walking. I'm sorry, I'm not even going to look at Christy anymore. She daggers me. So
That's
that
just my face.
we can spell out, because here's the bottom line. I see this law as an opportunity for you all to send a clearer message to booth rental salons. You guys got to up your game. And if you do up your game, then we're going to put this little carrot out in front of you of removing the responsibility of the landlord to pay your fines. So we'll incentivize the establishment owner to have the booth renters get their act together and to get a contract and spell out their lines of responsibility. Make sure their booth renters get liability insurance because you're concerned about that because your job is to protect consumers. And make sure that each individual booth renter has their own business permit that they're posted at their station because you're also in the business of giving information to consumers about who they're dealing with. And most, if not all, consumers have no idea when they walk into an independent contractor salon that they are actually dealing with two different businesses. The reception desk is one business, and the booth is a totally separate business, or at least it should be if they're legit. So I see this as an opportunity to start down the path. It's not booth rental license yet, but at least start down the path of giving an incentive for these guys to raise their professionalism.
Dr. Carey?
Thank you. Yes.
So while at the end of the day, I actually agree with Mr. Jones, I just would like to remind the board that this is not a booth rental license legislation. It is chaptered legislation that we are required to implement. And we do not have the authority nor the staff to look at every inspection that we get in to determine if somebody's a booth renter or an independent contractor, because we don't ask that, we don't get that, we don't have the authority to get that. While personally, my own personal belief, we should have a booth rental license, but that's, in my opinion, not in implementing this legislation.
You're saying not to implement this?
I don't think we can turn this into a booth rental
Oh,
discussion
gotcha.
to implement this legislation.
Understood. I did have a question. With the way that it's written now, knowing that the intent, again, is to make sure that we're not getting these double fines. Another instance in which it happens is, let's say, the individual licensee, when they're not present, the establishment owner still gets a license. And I know we're trying to define how the inspector will distinguish that. So I guess I can anticipate, like, in a DRC hearing, an establishment owner coming before us and saying, okay, this dirty comb was found in this individual licensee station, but they weren't present.
Correct.
And I guess, how would that be handled?
It would be on the establishment owner.
Okay, so in that case,
Right.
the individual is not present, then the establishment owner, and then we're limited, so then I guess it wouldn't be a double fine because that individual doesn't get the fine.
Right.
Okay, got it. Okay.
But if that individual is there and we go in and their station has dirty tools, or we see them, and the inspector knows, and they do that now, they write an individual inspection report. It's not going to change how our inspectors do their jobs. However, there's of course always room for improvement and training, making sure individuals are receiving their own individual inspection report. But if they get an individual inspection report, they're there, and we know, and we were able to tie the actual violation to that individual. Should the owner get that fine?
And that's what this regulation will determine.
That's what we have to determine how to
That's what
do.
we have to
Right.
determine with this. Okay, good.
Now, for staff, we look at things like, let's say they have no disinfectant in the shop. That should be on both of them. We have an individual who went to school and is clearly not disinfecting their tools. And we have an owner who should know that they should have disinfection available in their salons. That would be a fine that both would receive.
Understood, I agree, and to Ms. Bond's point, our legal representative, I think that to keep it simple, if we're able to develop, at least with this particular regulation, to set the standard, I definitely feel that establishment owners who have repetitive fines, so if it's the second, third, fourth offense, that at that point, they should have known. And then also going back to the seriousness or the egregiousness of the violation. And then, of course, because we do have our cite and fine committee, as you stated, when the report is then sent to cite and fine, then what the standards or how we work out how it's determined on that level, who the fine goes to, I think it will create some level of standard because.
I agree.
So is it a matter of us making a motion to include that language so we can move forward with this?
Which portion, that last portion you were talking about, what do you mean?
Or just adding oh yeah, I hear you, I hear you, Richard. Just being able to add that standard into the way it's written.
Oh, yeah, I think you'd want to make it clear what
Like,
standard you're
right,
using.
yes,
Yeah.
but if we were to make a motion to say, I move that we include the standard of, is that how we would do that for this?
Yeah, I think you could at least get moving forward if you were to explain clearly your intention. But there's not language, approval of language and initiating a rulemaking is going to require language.
So in other words, this is going to have to come back to the next board meeting.
I mean, unless it were so refined now
Which
that it
I'm
was-
fine with. My concern about timing is taking it to a committee when I can tell you I cannot have a committee meeting before our next board meeting,
I see.
Understood,
which would then prolong it to the
Right.
2 board meetings out.
I see what you mean.
understood. Mr. Hedges, I know you wanted to make a comment or ask a question?
Yeah, clearly, I'm supporting the comments that you're making, Carrie, Dr. Williams, but I just want to, from long-term DRC, say that we have establishment owner after establishment owner who have quasi-booth renters who come and believe that they're totally free of anything, they'll make that statement. And I think you may remember at the last board meeting, one licensee was saying that, and I told them, look, you can't relieve yourself of full responsibility for this. You get a lot of breaks by being a booth owner. You no longer pay into Social Security. You no longer have to have workers' comp. So you're getting a lot of breaks already, but you're serving the public. And we have to keep that in mind. They are serving the public when they put a license out there and will probably be sued as well as if somebody's injured, as well as the person that did the service under California common law. So I think it would be wrong to give anybody any further indication that they can avoid complete responsibility. So we have to craft this fairly carefully so that they understand that they may get a break on the first time, but they need to know it after that.
Can I just-
Yes.
I appreciate what Mr. Jones said about individual licensee, but those are not the only incidents that we see in DRC. With my limited experience, is that we get a lot of owners just saying, "I did not know." That's probably the most famous word that comes out of DRC. I did not know that he did not have a license, that kind of thing. I think we may, and I may be oversimplistic. I think we obviously cannot put every single details in this language here. There's just no way. And I think the intent of this is simply to say that now the authorized representative may determine that it's just the individual who will be cited, because at the end of the day, it goes to cite and fine to determine, because the representative at that time does not know whether the same citation has been given to the owner before, until it comes back to cite and fine. So that is not going to happen at the time of inspection. So all this language should say is that Now we're opening a door wherein the representative can determine at that time whether maybe the individual only is responsible for this specific inspection at that specific time. That to me is all should be here, is that yes, he can make the determination. The repeat and how egregious it is doesn't come in until it comes back to the office. So that's why I said leave it in number 2, because the representative inspector doesn't know whether they've been fined before for the same thing.
I agree.
If I could,
Yes.
there are times when they do know. For instance, the inspectors are required to do a follow-up inspection by the state most often after the first initial violation. So there are times when the inspector will know, but Coco makes an excellent point that there are many times when they won't know.
Yes, I agree with Coco's comments that just to keep it simple, knowing that the intention is just to get this process
available.
started and make it available, that we do oftentimes see that Cite and Fine will oftentimes remove certain violations from a citation. They'll adjust fine amounts, so I do have faith in our staff and what I've been able to experience with their decision-making after the initial report is submitted, that we do at least open the door for this to happen and eliminate these double fines that we keep seeing and also getting complaints about.
So can I ask Rebecca a question? If we removed A and just had B, but saying instead of setting fines, because that actually doesn't make sense, in assessing fines first up and then continue on.
Oh, interesting. In assessing factors. You might need a touch more clarity as to, I mean, I think that actually has a lot of potential in the sense that you're zeroing in on the standards that were mentioned by the statute. The only thing is it leaves a little vague when it goes to which, if that makes sense. You know, the statute is saying, who are you assessing it to? And so this just says that they're going to consider those 2 factors. You might want to just add a little more to say, in other words, in considering those factors, you could cite both, or in considering those factors, you could cite the establishment owner as well, something like that, maybe.
Okay.
In assessing fines.
We
Well,
have-
and you'd have to take out who are cited, because then that sort of assumes that they both
Right.
have already been assessed, and so there's maybe some retooling, but that actually could be a good platform.
Okay, I see we have some public comment.
Jamie Schrabeck, Precision Nails. Maybe I'm just a little confused. I mean, don't you already, regardless of the issue of who's getting the violation or the citation rather, don't you already take into consideration the seriousness?
Yes.
And whether it's a first offense? Then why couldn't you ditch B, keep A, take out the part that says duly authorized representative, and just say unless the board determines that the individual bears direct sole responsibility for the violation, period, as Coco suggested, and then just leave it at that. If we're trying to get at the fact that we could either
That's what you're saying.
cite 2 people or 2 entities or just one, and just leave it at that. If we overcomplicate things and talk about, you know, how that's done, procedurally, it shouldn't matter. It's just that we're putting it out there. We have the option as a board to either cite 2 entities or just 1, and just leave it at that.
So you're saying that would read as, the board may cite and fine both the establishment owner and an individual working in that establishment for the same violation unless the board's evidence establishes that the individual bears direct sole responsibility for the violation.
Something to that effect. I said board determines, but the board's evidence, I don't know if you know what the word
Establishes,
evidence in there.
determines, sure.
Yeah. But just to simplify it and not get into the weeds about how that determination is made. Because that's more procedural.
Well, I think that how that determination is made is kind of important. It was important in the statute, and also
But it applies to every fine, regardless of whether we're going to cite 2 people or 1 person. I mean, just in determining at what level you're going to fine somebody.
Okay, so your premise is, you're always looking at egregiousness as
Yes.
to whether or not to cite them.
Yes.
This is saying, with specific regard of whether or not to cite both the establishment owner and the individual. You're saying, as a basic premise, you're already going to look at egregiousness as to whether to cite somebody. This is
Right.
specifically talking about whether to cite both or just one.
It's just saying that the board has the option. In the past, you've been obligated to cite both, correct?
Right.
Now you have the option to choose one or the other.
Right.
So, and I mean, I think a question might become when the board says, well, it's just you that has direct sole responsibility, and when it wouldn't, which is, I think, precisely what the statute is trying to ask you to do. It's trying to say, well, when do you determine that the individual bears direct sole responsibility? When is that, as opposed to other times? I mean, you know, what's the distinction?
Well, the distinction is when someone's there, which is what we do now.
So then you could say that in a reg. You could say, if the individual wasn't there, then that would mean that we cite whatever that means.
But we would still need to say that if there's still a time when they're there that's egregious, that they both should be fined for.
So these are the kinds of things the statute is saying, break that down in regulation.
Right.
When are you deciding to cite both of them? When are you deciding to just do one? And when are you just deciding to do the establishment owner? That's what it's asking for. And so I think a lot of you have said, well, if you just stop it there, that seems to suggest one thing, right? Just the individual owns or has the responsibility. But I think the question is, well, how do you know? How do you determine that there's direct sole responsibility on the part of the individual?
I just don't see how we could do that in regulation, because it would be there would be a different explanation for that for every violation.
There'd be different examples for
example.
every. For example, if you had, say the unlicensed activity example. So you've got someone working in a salon that's not licensed. Maybe they lied to the owner. Maybe they forged
Right.
their license document. Maybe the owner didn't take it upon themselves to go to the BBC website to look that person up to see whether or not they had an active license. Yet that person has a station set up.
Okay, so
Whether that person's there or not, I think that person should be fined, and the establishment owner, do you hold that establishment owner responsible as well? Yes, because they're allowing someone unlicensed to work there. Whether or not that person is present or not, they've set it up that way. So I think if you're going to get in the weeds with every possible example, and then whether the person's there or not, I think that's going to be ridiculous.
Yeah.
And you're just going to have to establish that through how you treat these cases as they come, as you do now, because the inspectors will note violations, but even at the level of cite and fine, you guys aren't necessarily rubber stamping everything that the inspector notices. You could say that that's not really a violation, or there's an explanation for that we can't support citing and fining for.
Yeah.
All right, thank you.
Thank you. Okay.
Are we closer?
So, it sounds like we have a number of comments and recommendations on how this should be written.
I think what if in what she's saying, I think what she's saying is, as an example, let's say it's the unlicensed activity one, right? In theory, you guys would cite both, but then the establishment owner would come along and say, here's my evidence as to why I did not know. Here's my evidence why they lied to me or whatever, right? So then would you basically reevaluate and say, oh, never mind then, the individual bears sole and direct responsibility, and therefore remove one of the citations you've assessed, or dismiss it, I guess. Is that how that would play out, you know?
Potentially in DRC.
Right.
But we're looking to have our cite and fine be,
A little more
cite and
clear.
fine does this now
Right.
with certain, you know,
Right.
they look at first and second, third offenses.
I think that reason and from the last line of the statute are the two reasons I think you need a little more clarity as to the,
Okay.
and again, of course, I'm not at all trying to advocate for any kind, the level of detail that you're talking about would be needed for each and every little factual scenario, but in specifically, the statute says, in making these determinations, the board shall consider the following things. So I think what it's looking for in reg is how you consider those factors when you're assessing a citation.
Can we just repeat the statute?
Could I speak?
Well, I don't think that would get you
Yet, wait, hold on one second, Richard. Are you about to repeat the statute?
Oh, no, I wasn't asking you to repeat the statute, but
No,
I
no,
felt
no.
like the statute said it.
But then that wouldn't leave you with much, I think, because if you basically repeated it, which, by the way, OAL's regs talk about how repetition is not a,
Right.
a good standard for a reg anyway, but let's assume we're going to ignore that. Even if you still tried to do that, it would say, in making, I see what you're saying. You're saying, say, the board will consider these things when they
Right.
make the determinations. I see.
Right.
Sort of. I mean, you could take that and say, the board would look at, that's kind of what I was originally suggesting. Egregiousness and repetitiveness would suggest that the establishment owner is aware or
Right.
should have known.
Right.
So it's that kind of a thing. It kind
Okay.
of ties it with the standard, that consideration with the standard.
Right. Okay, so I think we need to bring it back at the next board meeting.
Christie, can I ask you a question?
Uh-huh.
Initially, when we were saying going to a committee would be taking too long, is it any reason why we maybe just take up this issue in a special board meeting that would happen before the next board meeting? We continue to kick the can?
Or a committee meeting scheduled in between.
Or is,
No.
or is it just, there's no time in which you could do that?
We can certainly look, the earliest, I can tell you all of February is out
Okay.
and all of March is out.
So it's next meeting anyway, in April.
Right.
basically. Okay, so
Right.
there's no kicking the can halfway down the road.
Right, right.
It's either kick it all the way down the road.
Right.
Or don't kick it at all.
So the earliest committee meeting we could have is in April. And then our board meeting's a couple weeks later. Right? When's our board meeting? April 23rd.
So can I speak now?
Yes, I'm sorry. Go ahead, Mr. Hedges.
And so, I want to say first of all that Mr. Jones, but actually I supported a lot of the comments you made, but Mr. Jones made a very good point about the difference between the good actors who are truly an independent booth salon and the bad actors who are trying to use it to avoid citations, or thought they were. So I would not support removing any part of B. I think that should stand as it is, because I think that first offense is a good indicator. And secondly, I think that rather than beating this up too bad, we could actually have Christie, with the staff, set up standards that we could approve through cite fine. That might be a way of handling this. But I'm really sensitive to what she's going through because we've been talking about it. They've had lots of people in the Glendale testing facility. She's had to spend almost all of her time down there. So she wasn't at the last DRC because of that. So we also need to, this is very important because it's a big change, but we also need to consider if there's someone sitting around going to the next board meeting, but having them just bring back standards if we approve this at the next board meeting.
Okay, thank you, Richard. So how do you suggest we move forward then? Christie?
I think that the board should direct staff to work with legal and come back at the next board meeting with proposed language.
I move that we do that.
I'm sorry, Richard, were you saying something?
I said if that's what Christie wants to do, then I would make that motion.
Okay, so Andrew was starting to make the motion.
I'm sorry, Andrew, go ahead.
I move that we direct the executive officer to work with legal to work on this regulation and bring it back at the next board meeting.
Then I would second that.
Okay, so we have a motion on the floor. Is there any public comment? Seeing no public comment, I'll start with a vote to my right.
Marilyn Morrow, yes.
Bobby Anderson, yes.
Andrew Rapkin, yes.
Dr. Carey Williams, yes.
Coco Lachine, I'm abstaining.
Lisa Tong, yes.
And on the,
Judges, yes.
okay, thank you so much. At this time, we're going to take a quick 10-minute break. Oh,
Sorry to interrupt,
sorry.
just for clarity of the vote, because of abstentions involved, that was 6 to 0 to 2. There were 2 abstentions because, yeah.
Oh, yes.
Well, actually, excuse me, I don't think, is that considered an abstention? She wasn't here.
She's not here, not present.
Yeah, so I guess actually it'd be 6 to 0 to 1. It'd be like a member not having been here to vote,
Okay.
I guess, yeah.
All right, thank you. So we're going to take a brief
You got that?
10-minute break.
6 to
We've
0 to
been,
1.
I mean, I know some, People have been taking some breaks, but let's go ahead and break for 10 minutes, and then we will revisit the next item on the agenda. All right, everyone, we're going to get started so we can finish going through regulations. Okay. So we're going to continue to go through the regulations as listed in item number 9 on the agenda. And I'm going to defer to Christy.
Okay, so the next item is also to implement an aspect of SB 1044, and that is to set the regulations for how we will allow for an installment payment plan for an individual or not a licensee who has received a citation that is over $500.
Okay. So are there any questions or comments about this regulation?
Christy, I have a question. Does the law actually state that number 2, 1/12 of the citations total, or is that the suggestion for the regulation?
That's just a suggestion.
Okay. I think that we should actually ask for slightly higher percentage for the first payment and the rest, the balance, stretch out accordingly.
Okay, is there any additional comments, questions regarding this regulation?
I have one question.
Yes.
So oftentimes, when inspectors are sent back after the first violation, there will be a number of the same violations, and even the third time. So if somebody's made a payment plan on the first time, and they're making minimal payments, and they keep accumulating violations, what do we do then?
Didn't we address that?
Is there an answer?
I'm looking. So we have it in there that if they fail to follow or complete the payment plan, but not necessarily when it comes to first and second.
So this could be, the only problem I see with this, I don't know how to, I'm not going to make a comment on how to fix it, is that if somebody's making minimal payments, they just go on their minimal way through the second, third, fourth, and fifth violations.
Well, isn't it answered here on C, if you fail to complete the payment terms or conditions for one citation, so you haven't completed your first one, you're ineligible to participate in the board's payment plan for future citations.
Do you read that, Kirsty? Is that correct?
Right,
Hamlet?
right. Yes.
Okay, then I'm fine.
Okay.
Thanks, Andrew.
No problem. So, I will move that we approve the proposed regulatory language and set it for hearing.
So I have a couple of concerns, over here from legal, sorry. Let's see. There's the BMP code section 125.9 that talks about not renewing a license if terms aren't paid. So I think there is a way to harmonize the language, but I think it needs to at least encompass that or address it. So I think I have a couple, let's see, I think I'd had a couple examples of that, but basically some language that says as long as the payment plan is being adhered to, then basically a way to acknowledge 125.9. In the interest of time, I'm just going to hit the main bullet points, and we can go from there. I think also you've got on A3, you have an approval, a note about approval, and I don't know that the board wants to be in a position to be determining whether or not they approve of each payment plan. I think the idea tends to be that it's available, and if you request it, we can put you on one. You just have to adhere to the terms of it. So I don't know that what you're looking to do is have an approval process. In other words, that would mean that you're kind of taking somebody's request and saying, well, we're only going to put you on a payment plan if, and then you're approving. So that's one thing with the language, and I think that can be resolved by perhaps saying something like, upon request of a payment plan, the following can be, set up, something like that. Let's see. Real minor, but there's a typo at the last word of subsection C. And then, let's see, and then you also have a form issue here as well. So in other words, if you want something on a form, you've either got to explain every data point you're going to put on that form in this reg, or you would incorporate the form by reference, using a title and a date to refer exactly to that form. That form that's in A1.
Okay.
Let's see. And then I think, and then in terms of simplicity, rather than breaking things down into 12ths, and this kind of goes to Coco's point in terms of payment and facility of payment, you might want to say something to the effect of not more than 12 payments or something like that, because let's say it's a $500 fine, and rather than doing 1/12, they say, give me 10 payments of $50 and I'll be done, and then it's in 10 months they're done, And so I think if you're maybe capping it and saying in no more than 12 monthly payments or something to that effect, maybe.
I like that.
I think that might be about all I've got at the moment. I think that the one that requires a little more retooling of the language is the one with 125.9. But I think, like I said, there is a way to harmonize that. It just needs to address the fact that 125.9 B5, the last line of it says a license shall not be renewed without payment of the renewal fee and fine. So I think there's a way, perhaps in your reg, you could say something to the effect of, compliance with a payment plan will be considered, partial payment or payment to satisfy 125.9.
Sorry, emergency alert, flooding.
Oh, yeah, we're all getting that. Mine too, yeah.
Emergency for me.
We don't know
Right?
how,
Emergency.
I'm from New York.
You're like, you don't know from weather.
We know how to drive.
So I think that encompasses my concerns.
Okay, so we do have a motion on the floor, but now we've received some,
Amend it to address.
Can we go back to the comments on 125.9?
Uh-huh.
What, can you say it again?
So 125.9 of the BNP code, so it's a general BNP code that talks about citations, just for everyone. B5 talks about failure to pay, and the last line says a license shall not be renewed without payment of the renewal and fine. In other words, you've got a payment plan and you're potentially going to be straddling renewal periods, and you don't want a situation where you've got them on a payment plan and they're due for renewal, and this statute 125.9 is saying you can't renew without payment of your fine. So you want a way to acknowledge 125.9 and say, okay, we're going to consider that payment, or because you're complying with a payment plan.
In order to renew.
Yes, because your reg is laying out, hey, we get it, you're on a payment plan, but that's not going to stop you from renewing. I think, where was that? That was failure to, I think you had a portion in here that talked about how you can,
D.
D, thank you guys, thanks. So, yes, thank you. You're permitted to renew. So in other words, I'm just saying in terms of the language, to achieve that same result while acknowledging the statute that already exists that on its face would seem to prevent that. So it's a matter of citing that as one of the authority statutes and just stating in the language that pursuant to 125.9, for example, we will consider adhering to a payment plan payment for those purposes.
Okay.
Do you see what I mean?
Yes.
Okay. I think in terms of where you go with your reg, it might depend on your timing, but when you asked about altering the motion, you could, I suppose you could implement these changes, but, in other words, you could amend your motion to say implement those changes, but it's a fair amount, so I don't know if it's something where you want to see the language back in front of you at that point. So you have two options there.
Okay. All right, so we do have a current motion on the floor. So I would like to ask for public comment.
Jamie Schrabeck, Precision Nails, just 2 points. Is there any sort of notification as part of the BBC's online system, Breeze, to indicate that if someone's trying to verify a license, that that license is currently in a payment plan situation on fines? What are the different statuses? Like if it's,
Nope.
Well, I think-
it's just inactive, what are the different ones that we have right now?
I think it'd be the same thing as showing a citation.
Right. Outstanding fines.
It would show outstanding fines during a payment plan.
It hasn't been established yet, so.
Okay.
Well, keep in mind, in terms of license lookup, this is not an additional violation or anything
Right.
new. This is just a way for them to deal with something that was already established or proven. In other words, the citation.
Okay, and then what happens should the salon change ownership during this, say this is an establishment owner that's been
Same thing
fined?
that happens with
Which
what
means
happens now.
they get to ditch the fines.
Yep.
Got it.
I mean, they'd stay on their record and they would never be able to come back unless they paid their fines, but.
Is there any additional public comment? So do we need to amend the motion?
It depends on what you're intending to achieve, because at this point, the motion is to approve this language that you have in
And
front
there
of
have been
you.
recommendations for updating the language.
Right, so in terms of,
It's a simpler problem, it's just to withdraw the motion, probably.
Okay. So you're, okay, so we're,
And then propose a second motion to adopt these regulations with the, or to,
okay, and this is where it would come to those two choices, I think. Either you're saying approve with suggested changes mentioned today, and then initiate a rulemaking process and delegate to your EO the ability to make non-substantive changes, or, and this is the board's prerogative, or ask for those changes to be implemented and to actually see the language again in that form before approving it and initiating a rulemaking process.
my motion is to take option A. That we approve with the suggested by legal and by Toto, to adopt or move forward with giving the executive officer the authority to do what needs to be done.
Okay.
I'll second.
For the first motion, I withdraw my second for the first and place it on the second motion.
okay, so we have a motion and a second. Is there any additional public comment? Okay, seeing no additional public comment, we'll now call for a vote, and I will start to my left.
Lisa Tong, yes.
Coco Shin, yes.
Dr. Carrie Williams, yes.
Andrew Drafton, yes.
Holly Cortez, yes.
Bobby Anderson, yes.
Mary Lou Amaro, yes.
On the phone?
With changes, yes.
Okay, so the motion passes, and we move on to the final point under item 9.
These are going to be easy.
That's what you said.
Did I? Yes. Okay, so this final package is recommendations on how we can clean up some of our health and safety regulations that we implemented back in 2015. So we start off with section 978, adding the word disinfectant to what can be labeled, we changed the regulation to say your disinfectant container has to be labeled disinfectant solution. Well, people buy containers that are pre-labeled disinfectant, and they're getting fined. So we want it to just be either it can be either one. So that's that first change.
Which, small note on the typo where you'd want quotes around both, I believe.
On the memo?
Oh, I thought you were on the first change in the reg language.
Specific language, item number 4, there's no open quote in parentheses.
Got it. Next is a cleanup of 979A and 979F for the cleaning process. So that's 979A is the non-electrical instruments. And we had created in the last change 979F, which is for the shears, but is that right? The specific process that is defined in each of those is the same. So it's just a cleanup to combine it to just be one. Next is one that our DRC members, I think, will love. That's our clean electrical tools, with the exception of hot styling tools, be kept in a clean and labeled space that is covered.
Yes.
Okay?
Question.
Yes.
So, in reading this language, how do I know that I can hang my clippers now soiled?
So we went back to the way it actually was before, which before we don't specify what you have to do with your clippers when they're soiled. So if you want to hang them, you can hang them. If you want to put them in the little hole in the station, you can put them there. But our focus is shifting to what are you doing with your clean clippers and keeping those clean between each clients.
Okay, well, bless you. This was such a curve to the industry that we told they could do that for so many years.
Yes. Okay, so next is clarifies that the minimum requirement for maintaining the supply of liners for foot spas, which, what did I say there? Is per chair, right? So just a clarification on what they have to have in stock. Then it talks about our next section, which is in 980.4, clarifies that any component that comes in contact with the water or a pedicure customer's feet in a tub or foot basin that uses liners must be cleaned under the process of section 979. So what we're finding now is the salons are converting to the magnetic jets for the foot spas, and the magnetic jets go inside the liner, and then that comes out, so that we never address what they are doing with those once it comes out. So it needs to follow the same procedures you would for any other non-electrical tool. Okay. Next, excuse me, is my favorite.
My favorite.
Removing the requirement to label an item new. The next is removes the labeling requirement for electrology sanitized tools. And that is because electrologists have to go through the sterilization process, so it's on their package anyways. So it's a totally different process than 979, and those package have color indicators on them that, and then we're adding them to write on them. Next is, we made just a clarification in our past regulations. We had the word scabies, and then in parentheses we had crabs, and we were contacted by a national association that wanted to make sure we understood those are two different things. So we're just cleaning up our regulation to make sure we note that those are two different things. And then lastly, we are adding the words device or machine to items that cannot be used if they are disapproved by the FDA. So that if there is certain facial machines that are disapproved by the FDA, that we cannot have them in our salons. And that's it.
Okay, are there any questions or comments? Okay, I see some public comment.
Hi, Fred Jones, PBFC. Love all the changes with one caveat or question. Yeah, I'm sorry, I'm on a roll. 980, why do we have to use the word covered on the clippers? So if immediately after the client service, the protocol of disinfecting the spray and wipe happens, they wouldn't be able to hang that clipper on a clean place.
No.
So
want-
they basically have to do it right before each client?
No.
So you're gonna have to have electrical equipment put in a covered place until right before it's used on each individual client. I'm just, all I'm doing is balking on the word covered.
The problem right now is that their clean clippers are out because it's not required to be covered, and so hair's everywhere in the salon.
Right.
And now your clean tool that's sitting there is no longer clean. That's why it's being changed to include covered.
Right. I'm just wondering how realistic that's gonna be out in the field. Because I'll defer to licensees, but typically they clean them immediately after the service, so it's clean. They hang it right behind them or on a hook. It's not
No.
coming into contact with anything
They can
other
hang-
than the air.
They can hang them dirty, and then they clean them right before their client.
Right, so that's what I'm saying. What you're doing is you're requiring the cleaning and disinfecting to happen immediately before each client.
Why?
Because if they don't have a covered place, because again, remember, these have electrical cords. So you'd have to unplug it, put it in a container, close the container, go about your business, then a client comes, open the container. That's what you're saying. But what in reality happens is they immediately finish a client, they clean them, and they hang them. And then they bring the next person up. That could be immediately, or it could be admittedly, 15 minutes later, an hour later. You're saying that's inappropriate with this, because it would have to be stored in a cupboard.
The board is saying.
Right. Well, so let me just suggest, I think the word covered is problematic. I understand the intent, but I'm just telling you, it's probably not going to happen in the real world this way. If you want to leave the clippers covered overnight after they've been disinfected, that's one thing. But between each service, the typical protocol is to clean them immediately after each service, hang them, and wait for the next person. So I think we might be causing a problem with that.
Thank you.
Jamie Schrabeck, Precision Nails. Surprisingly, I only have two things to say. The most common electrical tool in a nail salon is going to be a drill or an e-file. And that's not really addressed here at all. And most of them just leave it right on their station all the time. And it's the handpiece that they're holding, so they're not likely to disinfect that even though they've touched the client's hands and now they're touching this handpiece. They're going to be focused more on the bit or the arbor band, which is the disposable. It's like having a file at the very end. So that's something that I think we need to consider in this whole issue of disinfecting electrical tools. And then on section 982, we were talking about sterilizing the tools. I happen to use an autoclave in my salon, but I think this should go a step further and say that if you are misrepresenting the standard of sanitation that you're using in your salon by using those packages, and this happens a lot, where people will buy the packages and they'll put their tools in it and pretend like they've autoclaved them. They don't even have the equipment. They have the, and mind you, there are manufacturers of the packages that promote this. They're not the actual manufacturers of the packages, they're just reselling it. But I think that should be a fine for misrepresenting by using those sterilization packages when you don't have the equipment.
Oh, we do, well, we don't fine for them to use those pouches.
But they should be, because those pouches do say sterilization, and whenever
Right.
anyone sees
They're
those,
labeling over it, is what we're finding now.
I don't think they
They're
should be
so-
able to use the packages at all, because those, everywhere you go, whether it's a dental office or a medical office, you as a consumer understand that that package indicates a certain level of cleanliness, and I think to use those packages without the appropriate equipment is completely misleading.
Thank you.
Dr. Washington, I strongly support what Fred said about 980 disinfectant electrical tools, about them being covered. I think it's not realistic. You're not going to see it happening. You're just going to continue to get fines, and I think we're creating an unnecessary problem that we don't need. As you said, I am currently in the field, and I still cut hair. even though I may use a drawer to put mine in, but some of the people that work with me, they do not. They prefer to use the hangers. And like you said, they service the clients. After they finish, they clean the clippers, get the hair off of them, hang them. Next client come in, they disinfect them again, and start servicing another client. So I think it's something that you probably need to take another visit at that and look at that and reconsider it. Thank you very much.
Just to comment on
Yes.
what you just said, I think actually the way that it's written, then that would be in accordance with the regulation, that if they're just dusting them and hanging them, they're still considered
No, I-
soil,
I
and then
said-
right before, they spray and disinfect them, so then that would be appropriate.
Yes, disinfectant, yes, they clean them up, hang the clippers up,
Right.
and then before they use them again, they do it again.
No, yeah, I understand. So I think, based on what you're saying, because I too am a barber, and I know that the practice typically is, and it was much easier to Richard Hedges' point, when we have our clippers and we're in use and we're actively engaging in back-to-back services, that we can dust the clippers and hang them soiled. And then, like you said, it is a common practice for barbers to spray disinfectant on the clippers prior to using them. It's great because, one, we have to disinfect the clippers, but two, our guests like to see that you're disinfecting your clippers before you use
Exactly.
them. So I think the way that it's written is saying that when it's stored. So to Mr. Jones's point, at the end of the day, you clean, disinfect, you store them in a covered place. Let's say an inspector follows you in the morning, then if they want to see your clippers, like if I'm, when I'm inspected, I store mine, so the inspector says, let me see your clippers, I would present them. But if I'm in service and they're hanging, then the assumption would be that they're hanging soil.
Well, that's two different things we're talking about, At the end of the day, it's not written to specify at the end of the day that your tools
Well, I
are...
think it's more so stored, like how you're storing or how you're storing your clippers. So I think,
If you're in between clients, you clean your tools up, you hang them up, you go to lunch.
Right. They're
You
stored.
You come back, they're stored.
Right, so I think the way that it's written is it's
But it's
saying
saying covered.
disinfected electrical tools need to be covered. So if you are serving a client and you hang your clippers and they're soiled, they're not disinfected, so you wouldn't be fined. But if you are stating that these clippers are actually disinfected and clean, then they should be stored. So I don't think there would be a violation in that case. You can serve a client, dust them free of hair, hang them soiled, go to lunch, an inspector comes in, and you can say those are soiled clippers, you wouldn't be fined. If you say those are clean or disinfected, then you would be fined.
Okay, I understand. that.
Right? So then you would be okay.
It's the covered
It's the-
portion. It's the covered portion that I'm concerned about.
Right, and I think the way it's written is saying shall be stored in a clean and covered place. So if you're storing your clippers, meaning you are done using them and you're putting them away, they should be stored, kept in a clean, covered place. And they're disinfected. I think the key words are disinfect, stored, and covered. So if you're going to hang your clippers and not disinfect them, then they're fine. But if you're hanging your clippers and saying they're clean, then you would be fined.
I don't agree with that, but I'll accept it. I just don't like the way it's written. It's the covered, the word covered is what I'm concerned about.
And I understand.
I think it's very confusing, like he's saying, especially when it's the interpretation of the inspector.
Right.
I've come across this, that I've had people ask me questions about, what's in the books and legal, and it can be misinterpreted if you are, whether you're through for the day or not. That's.
I think the operating word is disinfected. So if I disinfect my clippers, I should store them in a clean, covered place.
If you're through for the day.
Or not even if I'm through, if I'm disinfecting them. So what Dr. Williams, Washington, what Dr. Washington described, which is a common practice for a barber, is he says, I do a haircut, I dust my clippers, I hang them. a client comes in, I disinfect my clippers, and I do a haircut. He's within the regulation.
Yeah.
He wouldn't be fined. Yes. So,
Can I
I-
ask a question on that? Okay, so when the inspector comes in and he sees that the clippers are clean, even though they're soiled, because all you did was wipe, how is the inspector gonna know?
if, say that one more time so I can make sure I
Okay,
understand.
so he did a haircut, he cleaned his clippers, hanged them up, the inspector walks in, the inspector says, well, those clippers look clean. How is he gonna know, the inspector, if they're clean or soiled, if they've been wiped off?
Because you would have to then put them in a cupboard and cover them if they were clean.
Yeah, but they're clean, hanging up, not disinfected, they're just cleaned. You see what I mean? He just cleaned them, he didn't disinfect them.
You mean like he
Yeah, he
removed
took the
hair and
hair off,
debris, right? Uh-huh. And then inspector walks in and he's there, or whether he's there or not.
And the inspector says, well, those clippers look clean to me. The inspector might think that they're disinfected, but when they're not.
Understood.
You see what I mean? So how does he get, I mean, I have the same, I store mine, but I do clipper cuts also. But I wanted to ask, that was my question.
Now, I was gonna say one other thing too, you know, now they're selling, and some of the people that work with me, they have the little cases that they sit the clippers on and they work out of the case. How would that be interpreted?
Is it closed?
Yeah, they do, they have case that you can just take and, you know, you can put 5 or 6 clippers on the case and just work off of your station. You grab a clipper, you're working, and you're using one clipper, but you got 4
So
or
they're-
5, yes.
They're in, so you're saying like they're in use, or are all the clippers in use, or you're just saying that's how they store them, but they work from that case?
They're all stored. That's the way they sell little cases like that now, where you can buy it and just sit down and put 4 or 5 clippers, and you work out of that case,
Well-
back and forth.
Is it enclosed?
It's enclosed.
I guess I'm trying to envision it. Is a case that you open?
Yes.
Like this? I mean, the first thought I would have is the same way that you have clipper guards, and the recommendation I typically give in DRC is how you have your SMA, you remove any items you're gonna use or have in use, so that they're accessible, so you don't have your clean box open where debris, can fly in. So if I have multiple, you know, let's say I'm using 3 different clippers because of the cut I'm doing, I would lay them out so I have access to them. If I have a case of 5, maybe I'll close the case with the 2 that I'm not using so they don't get dirty, and then
Okay.
have them laid out.
What about, if your clippers have detachable heads?
The guards.
No, not guards, but.
Oh, the actual.
The actual,
Blades.
blades, excuse me. You know, detachable
Like a Oster or
blades.
something?
Yes. I mean, do you have to store the clipper that doesn't have a blade? Do you see what I'm saying?
Right.
Because it's not a tool you can use on somebody without the blade. If you detach the blade and sanitize it and put it into a blade tray that's enclosed, do you have to store the actual,
I think that speaks to kind of what Jamie was saying about, like, for manicures, like the drill, how do you have the drill bit and then you have,
so if it doesn't, I'm just bringing up another mess.
I guess it's, I'm sorry, go ahead.
When, we asked an inspector before about the cases, because our students have shear cases that they store their shears in, but they have a little, like a velvety liner. When you store them, they have to be stored in a container that can be sanitized.
Right.
And if the case, the ones I've seen are like a sponge, if they can't be sanitized, then the clippers can't be stored in there. And plus, when you sanitize the clippers, you're gonna wipe down the clipper and all the cord, everything is gonna be sanitized. So how hard is it at the end of the day to wrap them up and put them away? And if they're a blade, or you can use clipper side to run the blades through the clipper side, which sanitizes the clippers as well. And one of the problems that we run into a lot is that the students, for us, don't read the directions on the spray disinfectant. They have to stay wet for 10 minutes. So if they're using spray in the salon, same things. Or barbershop, they need to stay wet for the amount of time. Or now that we can use wipes, that would be appropriate as well, I would think.
So I think to Dr. Washington's point, and I'm also hearing some of the other board members' concerns about the covered, I think the confusion, and I guess we need to figure out what we do about that, is for practicing barbers, if they are keeping their clippers hanging. What Ms. Amaro brought up a good point. Let's say a barber does go to lunch and an inspector walks in and thinks they're storing clean clippers because they took the time to remove debris, then that does create confusion.
Can I make a point here?
Yes.
So, 980 is to correct the problem we had when one of the agencies changed the regulation to require them to be cleaned and covered every time they're used. The industry likes to hang them soiled. We got a lot of negative comments after that happened, and we didn't mean for it to happen. That's just correcting this problem and going back to the way we did it in the past. I don't think you can write a regulation for when somebody goes to lunch. That's what the DRC is for, and that's what cite and fines for. So I'm going to support it the way it's written, because it's the way it was written, and it was changed inadvertently to something very negative for the industry.
Thank you. We have some public comment?
Well put, Rich. One thing you have to understand, as being a past board member, a lot of times it was never demonstrated to me where a lot of these issues came from. I mean, how many cases of cross-contamination did we have from something being covered or uncovered? This idea of hair floating around, well, in cosmetology, it's usually clean hair because 9 times out of 10, we cleanse hair before we cut it. In the barber culture, they work with dry hair. Sometimes you got to take a step back and look at the culture of who you're talking to. You know, we have multiple licensees, but we also have multiple cultures, business cultures. The business of cosmetology is for beautification. The barber culture is about grooming. Those are two different cultures. Barbers work on dry hair. They work at high volume. Any little thing. The reason why Dr. Carey might have 5 clippers with different heads is so that she doesn't have to take the time to rechange those heads all the time. Because in barbering, even more than cosmetology, time is money. Some of those cats and ladies, they turn out 10 heads sometimes in an hour. So anything that we do that creates an unnecessary burden, as Richard so well stated, actually creates more problems, and it becomes a gotcha for the inspectors, and then it becomes a nightmare for the appeals process. And having sat through thousands of those, much like you guys have, I can tell you something. Anything that will lower that threshold of appeals is going to be a plus to you in a lot of other areas.
Agreed.
So I would bare feet and maybe sometimes ask the questions. Well, how many people complained or showed up with some problem from a dirty clipper? You know, we know from the nippers sometimes, from the manicures, why? Because that's the only thing we can die from. You can get a pedicure to die for. But I haven't ever had it demonstrated in my 40-year plus as a cosmetologist and as a former board president. How many cases did we have to where it requires this level that's also going to be an unnecessary burden on them? And I think Carrie really said it well, is that you have to word it in such a way to say, listen, when you're done for the day, or if you're going to be gone for an extended period of time, it needs to be clean and covered, period, or whatever you guys do it. But I have never gone in a barber shop, and wherever I am in the world, I've been all over the world. I've had shaves in Durban, South Africa. I've seen barbers all over the world. And the thing is that I've never seen them put something away covered. It's always hanging on the side. So if it works that when it's hanging, it's dirty, and when it's put away, it's clean, as good as you can make that stated. Because every time y'all state something too like that, how are you going to get to all these people who've been doing it some other way? And I think that it goes back to your new education thing that you're handing out to people, that these new things always have to be upgraded in there, because that's the voice that's going to get to them, because ain't nobody talking to anybody out there. All right?
Thank you. Well, I agree with Richard to just have the language read as it is, because of a lot of the backlash that we've received, specifically from the barbering community when it was changed. And this does, at least the way that it's written, allow barbers to hang their clippers as they always have done. I see we have more public comment.
From an aesthetics point of view, we also lay out an SMA. So if you're going to talk about storage, you're also going to have to talk about duration, because it does exactly create a point where an inspector maybe comes in when you're setting up for the next one, and they come in and go, well, how long has that bowl been there? Or that electronic spatula out and sitting there? We don't know. So are you saying that we have to set up our SMAs while the client is in the room? Or can you do it in between services? Because if we have something that we've laid out, we've had instances where people have messaged me and discussed that they've laid their things out, an inspector comes in, and then they write them up for having like something out that isn't labeled new, or how can I tell if this is new, or how can I tell if that bowl has been cleansed, or that tool has been sanitized. So it's almost a situation where, again, consistency in the inspections and working in cooperation with these inspectors in a genteel way is going to be really important for us. And we're at an adversarial situation where we're just constantly getting hit with this, oh, I see a violation, I'm going to write you up, and it it increases the not very good positive relationship we have with inspectors.
This particular regulation is speaking to electrical tools. My comment about the SMA was specifically to his question about the clippers.
Right, but I'm saying for this also involves like our little handheld spatulas that are electrical tools and things like that. Sometimes our microdermabrasion machines and things like that are corded to the wall. And if we have heads or anything like that placed out, we've had comments where inspectors are like, well, how do I really know that that's been cleaned? So that's another inconsistency in the inspection process. So we have to understand more about what duration is.
Well, I think typically the SMA is laid out when it's in use. So an SMA designates or
But we
pretty much
don't
signifies-
necessarily lay them out while the client is laying on the bed. We lay them out as we prepare for the client to come into service.
No, understood, and that's okay.
Okay. So then again, we have to define what the duration of either storage or how long we're allowed to have out that SMA is, right?
Well, again, I think this regulation is speaking specifically to disinfecting electrical tools and how they're stored. I think with you questioning the SMA and how long they're sitting out, I think this, at least from what I'm reading, this regulation is not speaking to how you lay out your SMA. Because again, when you have an electrical tool, you're about to use it, and you retrieve it, you set up your SMA for a client that's coming in, or like you said, you're preparing for a client. Or maybe I'm not understanding your question.
Okay, so, that's fine. That's fine.
But we don't regulate SMAs at all. I mean, we don't have any requirements.
Yeah, and to your question, there's no regulation around the SMA. I was just using it as a way to identify the several clippers in a case.
If I may, I know it's my second bite at this apple, forgive me. All right, so I understand the intent by using the word covered. It's kind of like it's self-contained, if it's clean, it's clean. But it's not sufficient to be covered. If an inspector sees that it's covered, does that mean it's been disinfected? No. It needs to be clean, right? Because if they open it and see a bunch of hair, right? So the only way, there's two ways of going about this, the negative or the positive. Basically, the only way an inspector can at least hope that something's been disinfected is if there's no debris on it or near it. Because they're not going to know if it has an EPA disinfectant that's been in it. And even if it's covered, that's not sufficient. They'll open it and they'll see if there's debris. That's why it says clean and covered. So I guess what I'm driving at is, how much more assurance will an inspector have because something's covered? And weigh that against reality, that nobody is covering their clippers, ever.
That's not true.
Well, I don't know, there's industry here. I'm just saying.
Thousands of barber shops we inspect and their clippers are covered.
All right, well, I just don't, The fact that it's covered does not make it sufficiently clear that it's been disinfected. So even the covered equipment has to be open to look for debris. So I'm just, again, my suggestion is remove the word covered, but I know that causes all sorts of other concerns with you. But
So,
Yeah.
so clippers should just be anywhere, whether they're dirty or clean.
well, if they're hanging and they're clean, there's no debris on them. How is that any different than if something's in a cover? You don't know if either have been disinfected. All you know is, upon inspecting, there's no visible debris coming in contact
Right, but I'm
with
just,
it.
as a barber, should they not have to label any of their clippers? Or cover or anything? So they're just, it's just a free-for-all?
No, I'm not saying it's a free-for-all.
If
I'm
they're not-
just,
Are they labeled if they're hanging?
well, we discussed, like, for example, for shears, if they're in a non-disinfectable pouch, that's a problem.
Right.
We all get that. I'm not talking about that. I'm talking about something that has a long cord
Uh-huh.
that realistically, people are not going to be between clients putting it in a
Okay.
covered container. And so
Okay.
then it becomes a function of how does the inspector know if those are safe clippers?
Okay.
I don't think having a cover gives you necessary assurance that it is. Therefore, why require the cover?
What should it be then? How should barbers keep their
I
clippers?
have to remind everybody, this isn't public debate, it's public comment.
Good point, Mr. Hedges. I don't mean to be taking more time. I just don't want you guys to create something that creates a whole bunch of new conflict with licensees.
Understood.
Well, the intent of this is to clean up conflict that exists as
Yes.
it states right now.
Yes.
So if we adopt this and then they find that 10% doesn't quite, it's not gonna be 100% perfect, but we can always revisit it if it doesn't work a year from now or something like that. I don't think we need to, we don't have to seek be perfect first try out. I think we're gonna eliminate 85 to 90% of the problems with the way it is written right now.
Yes, Mr. Hedges.
This problem arose because another agency changed this language from what, we're changing it back to what it was, where it worked well, where most of the barbers hang the soils, brush them, spray them, wipe them, and use them as my barber does. So all we're doing is taking it back to a system that worked the best. Part of the problem happened outside us with the debate, very much like we're having within us today, that changed this language to require them all to be cleaned and covered. So all we're doing is making it easier for the industry.
And to support Mr. Hedges, if we look at the language that was struck out, the problem that we were having is that barbers typically hang their clippers soil. And the way that it was written was that they couldn't hang them soil. And so it was creating a lot of conflict for barbers because as we've been discussing, they would just hang them and disinfect them before using them. So we wanted to give them the opportunity to work and hang them. And so this language allows our barbers to do what they always do, which is they hang their clippers dirty. And now they won't be fined because when their clippers are dirty, they're not labeled dirty, as it was previously written.
I make a motion that we approve these regulations as written.
I second. I open back up for public comment. Seeing no public comment, I'll call for a vote, starting to my right.
Mary Lou Amaro, yes.
Bobby Anderson, yes.
Holly Cardenas, no.
Andrew Draftman, yes.
Dr. Carrie Williams, yes.
Coco Lachine, yes.
Lisa Tong, yes.
And on the phone?
Judges, yes.
Okay, so the motion carries, and we will move on to the next item on the agenda. Item number 10, which is a report and discussion on the hairstylist license requirements in other states, and I'll defer to Ms. Christie Underwood.
So at our last board meeting, this topic was brought up, and we were asked to do some research and get back to the board, which we have in your packet. on a hairstylist license. So we've provided some information of what NIC has, and then a chart that talks about the hairstylist licenses from all the other states. So that is just being presented to the board for discussion.
So if I may comment,
Yes.
Carrie and I went to the Sunset hearing, and we saw the makeup artists there trying to get a section carved out for themselves. And we've been through this, we've made our report. This is revisiting something we've already done. Because we've been required per the Sunset to review the 16-hour curriculum, for example, for cosmetology to perform an occupational analysis, and to review the exam. It is the natural progression that at the end of the reviews, we would have solid data, and we could say there needs to be a hairstylist license. But right now, we are clearly putting the cart before the horse because we're still involved with that, and we've already been through this to some extent with the makeup artist.
Thank you, Richard. Any additional comment, questions? Okay, I see there's some public comment.
Jerry Tyler, Professional Beauty Federation of California. I get to wear several hats. First of all, there's a company called Luxury Brand Partners. I urge the board to go to their website. There's a film that they produce called The Reset. And it lays out what's happened to our industry, where it's going, and what we have to revisit, because the industry needs a reset. A lot of the things we're doing is we're trying to turn a Volkswagen into a Porsche 911. And one of the recommendations in the reset, and I've been an advocate for this for the last probably 30 years, having traveled all over the world and educated over the world, cosmetology doesn't exist anywhere else unless you have a master's degree to do all three practices, which is the facial arts, the hair arts, and the nail arts. And particularly with the advent of all these new problematic things such as MRSA and other things, we don't need to have a comprehensive license that produces jack of all trades and master of none, not in these days and these times. And we're one of the only countries in the world where people go, get a very minimal education in things that can kill people. Nobody ever died from a pin curl, but you can get a pedicure and die from it. I've seen it happen. And so the idea, first of all, of just going back and looking at the three cultures that we have under cosmetology and separate them, because if I'm going to do nails, I need to have those 600 hours. If I'm going to do the facial arts, I need those 600 hours. And if I'm going to do hair, why do I have to? And I urge you to go back to the occupational analysis for the last, I don't know how many years. The cosmetologists, by and large, do not do nails. Some do hair and makeup, mostly in production. And that's because some productions cannot afford a hairdresser and a makeup artist. But in these days and times, being the largest, most powerful beauty board with the most licensees in a $7 billion industry, I would urge you to move forward on this, because if not, what we're doing is that we're trailing, we're not leading. If I want to do hair, skin, and nails in Switzerland, that's a 5-year apprenticeship, and I'm considered the same as a master's degree or a doctor. That's the level of expertise. But do you think anybody with 1,600 hours is going to be a view of master of anything when they're not a master of anything? So really, I would urge the board to move forward on this, because what's happening too is that with the changes that are going to be going on in the school industry as far as funding, and if you looked at all those different states, and you notice they didn't have one number of hours for hairstylist licenses. The states that had the highest cosmetology hours, some over 2,000 hours, their hairdressing only license is at 1,500 hours. Well, that's only 100 hours off for the cosmetology, so what's the big difference to us? So the thing is that you go back to the occupational analysis, find out what we don't do as hairstylists, and then relate that to the current cosmetology, get rid of that side. Cosmetology was created in the 50s because my mom would go to the hairdresser, she would have her hair rolled up, she'd get her nails done, they might give her coffee, she could give her lip waxed, all by one person. It's not like that anymore. We've become too technologically, creatively advanced to water down our industry right now. And so hairstylists, and by the last one I remember, I think it was 2004, Christy can correct me, that 92% of the cosmetologists don't do the other practices, and if they do, it's so minimal, it's not worth even mentioning. And why are we causing and forcing people who want to do hair to do nails and do facials when we don't force them to learn anything about what we do? So really, it's kind of discriminatory. And I think that's the last thing we need in these days and times. So I would urge you to move forward on this, and I guarantee you, you might get a little blowback from the for-profit schools, but in the end run, it's going to be better for them because it gives greater value to what they're teaching, and they can have people who really know what they're doing teaching it rather than jack of all trades and master of none. Thank you.
Thank you. I'll say to your point, Mr. Tyler, and also supporting Richard, that again, we're currently doing an occupational analysis. I agree that this is something that we need to do, but I think what we should do is allow us to continue to finish this occupational analysis that we're currently doing, which would more than likely provide us with more solid information that this is something we can move forward on, because when we went to the sunset hearing, we actually discussed not creating subcategories within cosmetology. So I think with the occupational analysis that we're currently in the process of doing, the information that we gather, then we can say, you know what? From this occupational analysis, we found that, yes, we need to establish this license, but to move forward with it today, I think would be really premature. So I don't think there's really any, that we're disagreeing with it. We just need more time to demonstrate that there is a need for it, especially, again, as was cited by Mr. Hedges, you know, the makeup artist wanted a subcategory, and we didn't go through with that, and then to suddenly say, okay, we'll do it for the hairstylist, it could potentially create some conflict within the industry.
Well, I think when it comes down to things like, sorry, I'm out of practice. I totally agreement with that. That it's good to take a look at, and that's the great thing about occupational analysis. The sad thing about occupational analysis is that in my 42 years of being in this game, I've never seen it followed. It's never been reflected. The information was gathered, we all look at it and go, why are we making hairdressers learn nails and nails not hair? When the nail people are, maybe you should have 1,000 hours. Who knows, But I totally agree with you, because once you have that, then that does say it. I don't see it as a subcategory. I really see it that the cosmetology, just that whole idea is just old. And if it was a real comprehensive, then it should be 3,000 hours or something, not 1,600, because the things that are the most problematic are the things least covered, which are in the skin and the manicure categories, because particularly in the skincare categories, they're technologically driven to a point it's hard to keep up with them even. I mean, I was just told that there's like 900 machines out there. So, point taken, and I'm totally in agreement as always, Gary.
All right, thank you. Are there any other questions or comments? Do we need to make
I would say one more thing.
Oh, yes.
So, I'm not disagreeing on the issue of a hairstylist license. I'm saying we need to wait till we know more. As Mr. Tyler said, you have 400 hours for the manicure, 600 hours for the esthetician. You have to realize that in both of those, a large number of those hours are rules and regulations and disinfection. So even if we did a hairstylist license, it wouldn't, and we exacted some of those hours for those skills, it still wouldn't reduce the number of hours a great deal that someone would have to do. But we really need to take a look at it first through this process we're going through.
Thank you. We have some more public comment.
Hi, everyone. Karen Barris. First time ever at a meeting, and I have to say, my new passion is to get more people here. So I'm going to be a voice. I don't know how it's going to come out. Started doing nails when I was 16, then hair, then skincare, then waxing. I've spent so many hours learning. I have to agree with Jerry. And it's just a voice, you're doing the research, but really, I have watched so many hairdressers fail and leave the industry in the first 3 years. My role was international trainer for a large company, 3 in the world. And it's sad. You said it perfectly. How'd you say it? Master of all trades? Jack of all trades. See, I knew something. I get nervous still. So I really think you should look at this, because I trained for 16 years in salons all over the globe. And it's sad. How many people have talent and leave and fail because they are not trained specifically in one thing? I think if they decide what they're doing or guided is one thing, like a period, a questionnaire when they go to school. I personally saw a chart, an organization chart. I can do this, I can do this, I can go here. And I feel like every school I walk into, their systems are different. I feel like it is, let's just pass them through. That's what my experience was. The only reason I stayed in this industry is because of mentors. That's it. And I became global trainer for the world's third largest company. I'm not saying that pat on the back, that's this. And I'm speaking now because it does need to be looked at.
Thank you so much. Is there any additional public comment? So do we have to make a motion?
No.
Okay, so this
There's
is
no
just discussion. Okay. So any additional questions, comments? Okay, seeing none, we will move on to the next agenda item, which is the annual review and approval of our board member guidelines and procedures.
I promise this one's gonna be easy. Okay, so this is your annual board member guidelines, and it has very minimal changes from anything that you've seen before. We added the definition of our new Health and Safety Advisory Committee. We've added information for the most current dates for training for board members, and updated our PO box number, which you already all have, and then the new 2016 travel guide as well. So very minimal changes, and that's it.
Okay, are there any questions or comments?
I have a question.
Is the general public PO or the one that I use when I write you a letter, Kristen?
What?
Is it a general,
Oh, no, it's not, it's not our full public, right? It is? Oh, no.
I needed to throw away some old envelopes.
I have a question under the DRC section.
Yes.
Will this change, given what we're now looking at? This particular section for disciplinary review committee, will this language change? Depending on what we decide?
Oh, right, yes.
Okay.
But probably not for at least a year, so.
On officers, on page 3, under chapter 2, so your manual specifies some guidance to your elections, and your statute, which makes sense, that's helpful, because your statute is pretty broad and doesn't say a whole lot. One suggestion for a lot of boards has been that you can specify in your policy manual how you would like the sort of transition to go. So for example, your statute might say, hold your elections at the first meeting of the year, but then you can have a smoother transition. A lot of boards have kind of like, okay, here's the gavel, or now we're all going to change seats and things like that, and it can get a little clunky, and it can also change expectations for running the meeting, and it can also affect, less so in your case when you have 2 separate days probably, but sometimes with some boards it can affect which president is then signing which decisions because of when they technically transitioned. So for example, a lot of boards have implemented in their policy manual, we hold our elections, and then at the conclusion of that meeting, the new officers take office or take their positions. So that's just a suggestion for some kind of clarity and streamlining of that process.
Okay, thank you. Okay, so at this time, do we have a motion to approve our updated board member guidelines and procedures manual?
I don't think we need it.
Do we need a motion?
Yes.
Okay.
Well, it depends on what you want to do. If you, yes, you would either move to keep this as is or to make any other changes you guys are considering.
Okay, so we have a motion to approve it as it is, which includes some of the changes that Ms. Underwood stated.
I don't think anything was changed.
Or added. She just added. Yeah.
From the previous version.
Yes.
Oh, I missed that.
We added our Health and Safety Advisory Committee, as well as the updated dates for orientation and training,
Gotcha, thanks.
and the PO box was updated. Okay. No, it was not seconded. Okay, so we have a motion on the floor. Is there any additional public comment? Seeing no public comment, I'll move for a vote, starting to my right.
Mary Lou Amaro, yes.
Bobby Anderson, yes.
Holly Cortez, yes.
Andrew Grafton, yes.
Dr. Carrie Williams, yes.
Kokolashin, yes.
Lisa Tong, yes.
And on the phone?
Rich Hedges, yes?
Okay, so it passes. We move on to the next agenda item, 13.
This, I promise, will be easy. So, at our last meeting, we talked about providing some information on the website, and we're actually, we just kind of put together sort of some cheat sheets that we could post online, just kind of tell people where to look for things. So we had done this because we had kind of liked the idea of it being a sort of a handout, as opposed to doing it on, actually on like the screen today. We were planning to do an on-screen one when we're back in Sacramento. But in the meantime, we wanted to just provide you with this information and kind of give you tips of what we would like to do for where people, letting people know where they can find information on our website.
Can we have our beautiful logo somewhere on the home pages?
I'm surprised our logo's not on the homepage. I think it's there somewhere.
Okay.
We'll check. It's gotta be there, right?
Okay, so any comment, questions? Seeing none, thank you so much, Ms. Underwood, for our website review. And the next item on our agenda are agenda items for our next meeting. Are there any agenda items for the next meeting?
I have one.
Yes.
So, when was this article published? Hold on. Back in middle of December 15th or 16th, there was an article in the New York Times about a bill that was passed in Illinois, which talked about requiring hairstylists to go through domestic violence training, not training in domestic violence, but observing, et cetera. And my initial, of course, reaction to the article was, no, that's not our role, what are we doing? But in thinking about it more, I'd like to take a look at what the law was that was written there. The article implied that the industry worked with the legislature on doing this, so it was kind of a tag team, we're all working on it together as opposed to adversarial. I'd just like to look into this subject a little bit more, seeing that our industry does cross all classes, ethnicities, et cetera. It might provide important help to people not necessarily served by other people. And in a day and age where places like Russia today talked about decriminalizing domestic violence or something like that, I'm a little bit more worried about protecting people. So it's just an idea to look into and see what it is before, there's a possibility, if I'm paying attention to it, other people are, and I'd rather be out in front of the issue and look at it as opposed to being reactionary to it and having to, might come down from the legislature to do it, and rather work with them than in opposition to them, possibly.
Okay. Thank you. Are there any other agenda items for next meeting?
I have a recommendation.
Yes.
We had a large amount of comment, which is good, from our legal staff today, but I'm going to urge legal to, any of this information that they bring up from the agenda, to contact Christie and go over some of the problems we may have before the meeting.
Absolutely.
Make it a lot less difficult to deal with if we know in advance, or we may have some problems.
Okay, thank you, Richard. Any additional items for the next meeting? And now we have some public comment. Yes.
Jamie Schrabeck, Precision Nails, to piggyback on what Mr. Drapkin just said, Ohio offers classes on human trafficking. So that's another item that is prevalent in our industry that does relate to domestic violence as well.
Okay, thank you. We have some more public comment.
Just on that note, the national, kind of the PBA, the Professional Beauty Association, has many areas under their umbrellas, and if you're considering looking at this, there's a program called Cut It Out. And they give actual training to hairstylists and licensees to recognize potential evidence of that. You know, John Steinbeck, who's one of my favorite authors, said that, do you know who the most influential people are in the world? They're beauty professionals. That's Steinbeck. And we sometimes might be the first person who could recognize something to where there's actually even now a code that if they could look at us, and if we know what that code is, we will call 911 because they might be watched by somebody else. And that goes for human trafficking, and it goes for also domestic abuse and violence and stuff. So look at Cut It Out, and then maybe see how we could maybe have a link from the website to our website for that, and that shows that we're really about community because we are community. Okay.
Thank you. Any additional comment for agenda items for the next meeting?
Yeah, I might make one more comment if I may.
Yes.
I actually think it's a good idea to give folks some training along those lines that Andrew was talking about, but there are some licensees like nurses and I think teachers that if they notice abuse and they don't report it, they can have their license revoked. I don't think we should ever get into that and try to control our licensees like that.
Agree.
And I probably agree with you on that. That's why the article talked about it, just giving training to, you know, and they talked about the limitations and stuff like that. But I think we should look at it as a frame of reference to see if it's something that we want to model or do something different. But
I agree.
Okay, I do see we have some more public comment.
Rich Campbell from Dermaflash again, and I would just like to formally request that I be put on the next agenda to see if we could demonstrate and further talk about Dermaflash as an alternative to dermaplaning in California. Again, I'd like to point out that we do regularly get requests from spas all over the United States, but in California as well, looking for an alternative to dermaplaning. What we offer is very safe, clean, safe and hygienic alternative, and we would very much like to demonstrate it and to talk further about it with you, if that's possible.
Okay.
Thank you.
All right, thank you. Are there any additional items for our agenda next meeting? Okay, seeing that, we'll move on to the final item on the agenda. Any additional public comment? Okay, seeing no additional public comment, I officially adjourn this meeting. Thank you so much.